Good afternoon. My name is Cliff Marchek. I'm the Coordinator of Community Service at the William S. Boyd School of Law. This particular video section is going to describe what we call a prove-up hearing. And that is if you are in either a paternity custody case or a divorce case, and there is no disagreement as to the issues remaining in the case, the parties can simply request a prove-up hearing to bring the case to a conclusion. The first example is in a divorce case in which there are no disagreements as to the material issues in the divorce. And you learned from our divorce videos that there are four main issues. If you have all four, or if you have less than four, but you've agreed on everything, you don't need to go to court and have a trial. Once the joint petition's been prepared and submitted, then the petitioner files a setting slip and sets a hearing in front of the judge to prove up the divorce. That's one way to do it. A second way to do it is if the complaint was filed by one of the parties. Again, this applies to a paternity custody action or a divorce lawsuit. If the defendant does not answer the complaint, if that happens 20 days after the complaint was personally served onto the defendant and there's been no answer filed, the plaintiff can go down to court and enter the default, which cuts off the defendant's ability to answer and contest the allegations in the complaint. And then the plaintiff can request a prove-up hearing in that setting. A third example is in a complaint for divorce. It's the same process. If the plaintiff filed a complaint, served it on to the defendant, and the defendant did not file an answer within 20 days, the plaintiff can enter the default and set the matter for a prove-up hearing. The fourth example is a complaint is filed and an answer is filed, but some point before the trial, the parties resolve all the issues. There's no need to go to court for a trial, and the parties can request a setting slip and set a prove-up hearing. Now, what a prove-up hearing is it requires the plaintiff at a minimum to go to court with generally a resident witness and put on a very short hearing in front of the judge so the judge is confident that the case has been resolved. The defendant is not always required to attend, though it is encouraged for the defendant to attend if the defendant happened to answer the complaint. What will happen is the plaintiff will bring the decree to court with him or her and generally his or her resident witness. When you go to court, the judge will call your case and you will go up and sit at the table that's marked plaintiff, and usually the resident witness will join you and any attorney if you have an attorney. Then there will be a series of questions asked by your attorney if you have an attorney, or you'll have to answer these from the judge. We have a list of these questions for you that we will provide you at the end of this video, but the questions go something like this. Ma'am, please state your name. Are you a resident of Clark County, Nevada? You caused a complaint for divorce to be filed in this case. Is that true? You allege in that complaint that you and your spouse were incompatible. Is that correct? Then there will be questions about if there are minor children, provisions for custody, visitation, and support. There'll be questions about the division of community property, which includes assets and debts if there is any community property. Whether or not there's going to be an award of spousal support, and if so, how much and how long will a party receive that? And last, whether or not the wife wants to have her maiden name restored. Once the hearing is concluded, the judge will sign the decree, and then you will take that original decree with your copies, and you always want to bring 2 or 3 copies of everything with you to court, go down to the first floor of the clerk's office, submit that original divorce, and the clerk will give you what are called conformed copies of your divorce. You are now divorced. Don't leave the courthouse with your decree without going to the clerk's office and having it filed. You are not actually divorced until that decree has been filed with the clerk's office.